My name is David Castellaw. I'm the Securities Training Manager at PFS Investments. The Edge for Series 63 is designed to help you pick up maybe 10 points on the exam. This is not the only thing you need to do to pass your test. You need to read the manual, you need to watch the videos, and you need to work on practice questions. Now let's get started. The 63 exam is a state securities license exam. This exam covers the Uniform Securities Act. On the exam, you'll probably see questions referring to the USA. That's the Uniform Securities Act. 60% of the exam will be on state security acts and related rules and regulations. 40% of the exam will be on ethical practices and fiduciary obligations. Now, this exam is 65 questions long. 60 questions will be scored, and there are 5 trial questions. Those trial questions will not be scored. If you get them right, they don't help you. If you get them wrong, they do not hurt you. You will not know what those 5 questions are. Now, you've got to score 72% correct to pass. That's 43 of the 60 questions that will be scored you must get right. This exam is 1¼ hours long. That's 75 minutes. Now, to help you as you work through the exam, remember the purpose of this act. This act is designed to protect the investing public. It's not designed to protect institutional investors, but investing public, you and I. Now, within the exam, you're going to have to be able to define certain things. There are going to be questions on the exam about definitions. The administrator would be the official or agency responsible for administering the USA. An agent represents a broker-dealer or issuer affecting or attempting to affect sales or purchases of securities, really important, folks, for compensation. For compensation. Blue sky. Now, this is a term that is common for state security law. Broker-dealer. Now, on the test, you'll probably see BD. This is any person, legal entity, like a partnership or a corporation, engaged in the business of effecting security transactions for others. They would be acting as a broker or as an agent or agency, or for their own account. They would be acting as a dealer or principal. Now, this is something that we learned with Series 6. Exempt securities would be a security exempt from state registration and advertise filing, but real important, folks, not exempt from the anti-fraud provisions of the USA. Now, we're going to get much deeper into exempt securities a bit later. Exempt transactions. These are transactions exempt from USA provisions, exempt from the law, but not the anti-fraud provision. So you cannot engage in fraudulent activity, even if a transaction is an exempt transaction. That would violate the USA. Federally covered advisors. These are advisors that would be required to register with the SEC in accordance with the National Securities Markets Improvement Act of 1996. Now, you'll probably see the Act of 1996 referred to with this acronym, NSMIA. Federally covered securities are exempt from state registration in accordance with NSMIA. A guaranteed security, guarantee of payment of principal, interest, or dividends by others, not the issuer, not the issuer. Now, I know you're probably saying, now wait a minute, we learned when we studied for Series 6 that we can't guarantee security. And you're right, you're right. You can't guarantee a security. A broker-dealer cannot guarantee a security. A security could be guaranteed by someone other than the issuer. An example of that would be if we have a company, a parent company, who has a subsidiary the subsidiary is selling new securities, the parent company could guarantee those new securities. Payment of principal, interest, or dividends by the parent company, not the issuer. And be careful, we cannot guarantee a capital gain. Investment advisor, an IA, any entity that would be compensated for giving investment advice. Now, this includes financial planners, sports and entertainment agents, and consultants to employee benefit plans. We'll explore investment advisors in more detail later. In fact, much of what we're looking at here, we're going to cover in more detail later. The investment advisor representative, the IAR, is an individual employed by or associated with an IA and is compensated for investment advice. So think about it this way. The agent represents the broker-dealer, the BD. The IAR represents the IA. So the IAR is to the IA what the agent is to the BD. Now, an issuer is any person who issues or proposes to issue securities. May not issue, but if they propose under the USA, they're an issuer. Non-issuer would be any person other than the issuer. What are we talking about here? Individual investors such as you and I. Now we have offer or offer to sell or sale or sale. Whoa, what is that? Well, an offer or offer to sell would be a solicitation to sell or solicitation to buy a security for value. What is a sale? Well, that's where we have the act of conveying ownership of a security for money or other value. Now, we're going to explore offer and sale in a bit more detail later. A person, very broadly defined by the USA. Look at it this way. If it can open an account, according to the USA, it's a person. Would an individual be a person? Sure. Would a corporation be a person? Under the USA, yes. Would the government be a person? Under the USA, yes. Because all of those could open an account. Now be careful here. Be careful. The USA is designed to protect the public, not persons. Because many persons, as defined by the USA, would not be the public. Many persons, as defined by the USA, would not be the public. Now let's start exploring some of the things we just looked at in detail. We start with the administrator, jurisdiction of the administrator. Now, the administrator has jurisdiction over any offer or acceptance in the state if originated in the state, directed to the state, accepted in the state. What about media offerings? Now, the administrator would have no jurisdiction if the TV or radio broadcast originated outside their state. Would have no jurisdiction if the newspaper or a periodical was published outside of their state. Would have no jurisdiction if a newspaper or periodical is published inside the state, but 2/3 of the circulation is outside the state, such as USA Today. Now remember, the administrator has the responsibility of enforcing the Uniform Securities Act. They have jurisdiction. They can enforce the Uniform Securities Act where? And that's what this is talking about. In the state where an offer acceptance was originated, directed, or accepted. So might we have multiple administrators having jurisdiction over the same matter? Absolutely. Absolutely. An offer originated in Georgia was directed to people in Alabama. Both the Georgia administrator and the Alabama administrator would have jurisdiction in that case. So if there was a violation of the Uniform Securities Act involved in that transaction, then the Georgia and Alabama administrators could get involved. Now, what are the powers of the administrator? They have the power to make rules and issue orders to enforce the USA. Now, I want to make sure you're real clear here. The administrator does not have the power to write law. Law is written by the state legislature. The administrator will write rules and issue orders that they would use to enforce the USA, that they would use to enforce the law. Now, what might an administrator do? They could deny, suspend, or revoke a registration and or a license. In order to do this, the administrator must give the party prior notice, opportunity for a hearing, support their action, and the administrator's order can be appealed to a state court within 60 days of such order. Let's kind of explore this just a little bit. Let's say that I'm an agent and I violated the provisions of the USA. I violated provisions of the USA. The administrators decided that they would like to suspend my registration, suspend my license. Before they take action, they must give me notice. Hey, Dave, we intend to suspend your license. I said, well, I want an opportunity for a hearing so I can defend myself. They must provide me that opportunity. Now, we have a hearing. Evidence is submitted. I submitted evidence. The administrator submits evidence. The administrator believes that a violation of the USA has occurred, so they suspend me. They have to be able to support their action. They have to be able to say, here is what David did, and here is the law, rule, or order that he violated. Got to be able to support their action. Now, once I have been suspended, then I have the right to appeal that decision by the administrator within 60 days of the suspension. Now, be careful. During that 60-day process, during the appeal process, my license stays suspended. So by virtue of filing an appeal does not stay or set aside the administrator's order. I'll still be suspended during the appeal. Now, summarily suspend pending registration. What does that mean? Well, that means that if I am applying for registration with the state and the administrator believes that I'm not qualified, they can suspend my pending registration followed by some type of investigation, if you will. Now, in this case, my pending registration is suspended and I was not provided prior notice. They let me know after the fact. Hey, by the way, we're suspending your pending registration. I could ask for a hearing, find out why, and defend myself, explain to them why I should be registered, would have to grant me that hearing within 15 days of my request. Now, we continue with powers of the administrator. The administrator can conduct investigations and issue subpoenas. Can they conduct investigations and issue subpoenas across state lines? Absolutely. An administrator in Georgia could require a broker-dealer in Colorado to produce books and records. You bet. You bet. So their investigations and the power to issue subpoenas crosses state lines. What else could an administrator do? They could issue a cease and desist order. They could seek court-ordered injunctions. They could refer a person to court, state court, for criminal prosecution, and they can publish information regarding violations. Now, rules and orders. Rules and orders have the same authority as the law. So if an administrator writes a rule or issues an order, has the same authority as state law, but is not state law. Now, any rule the administrator writes applies to all. So let's say that the state administrator creates a rule for broker-dealers in the state to follow. That rule applies to all broker-dealers in the state. What if instead the administrator issues an order such as a cease and desist order? That order only applies to the party the order was issued to, does not apply to all. Now, the administrator may deny, suspend, or revoke a registration if it's in the public interest and any of these things has occurred. Willfully violated the USA, filed an incomplete, false, or misleading registration application, convicted of any felony in the past 10 years, convicted of a securities-related misdemeanor in the past 10 years, subject to another administrator's denial, suspension, or revocation order, engage in dishonest or unethical securities practices, insolvent, liabilities exceed assets, if under court order enjoining from the securities business. So let's say that a broker-dealer or an agent or an investment advisor or an investment advisor representative is under a court order enjoining them from the securities business, stopping them from being part of the securities business. Then an administrator could deny, suspend, or revoke registration. If found guilty on a charge of failure to supervise, may deny, suspend, or revoke a registration. If the administrator finds that you are not qualified due to lack of training, experience, or knowledge, they can deny, suspend, or revoke registration. But please note right here, they may not deny, suspend, or revoke registration if you solely lack experience. Could the administrator deny your registration because they believe you have not been adequately trained, don't have the knowledge to do the business? Yes, they could. Could they deny or suspend or revoke your registration simply because you've never been in the securities industry before? No, they can't. No, they cannot. Now remember, who can have their registration denied, suspended, or revoked? It would be a broker-dealer, an agent, an investment advisor representative, even a security. Now, real important, and it's underlined there on the slides, this can only happen if it's in the public interest. Only if it's in the public interest. Now, conduct investigations and issue subpoenas. The administrator may make private or public investigations within or outside the state. I mentioned that a few moments ago. I mentioned that the administrator can conduct investigations outside of their state. Now, note that these investigations may be public or private. So the administrator could be investigating a broker-dealer and the broker-dealer not even know it, or an agent and the agent not even know it, or an IA or an IAR and they not even know it. Required statements to be in writing and under oath. So the administrator could require people to submit evidence in writing. They could require people to swear an oath during testimony, gather evidence and require production of books and records. Mentioned a moment ago, administrator in Georgia could require a broker-dealer in Colorado to produce books and records. Can subpoena witnesses, compel folks to attend hearings, and take testimony. So the administrator has an awful lot of power. They can issue cease and desist orders. Now, when would an administrator issue a cease and desist order? If they believe that a violation of the USA has occurred or is about to occur, then the administrator may issue a cease and desist order. Now, basically, this is an order that says if you are about to violate the law, don't do it. If you are violating the law, don't do it. Cease and desist. Now, before issuing this order, the administrator would not provide an opportunity for a hearing. They issue a cease and desist order to a broker-dealer. Broker-dealer says, I don't know why you've done this. I want a hearing. I want to see the reason. I'm going to provide evidence that I've done nothing wrong. Hearing is requested, must be provided within 15 days of the written request. Now let's say that an administrator has issued a cease and desist order to an investment advisor, and the investment advisor has ignored the cease and desist order. What could the administrator do? they could go to a state court and get a state court to issue an injunction, which basically would put that investment advisor out of business until the matter is resolved. Now, what type of penalties might a court impose for violations of the USA? Well, civil penalties would be client could recover the amount paid for a security or advice that they received from an investment advisor, less any income they received on the investment, such as dividends or interest, plus reasonable court costs and legal fees. So let's say that an agent has violated the Uniform Securities Act. A client sues over that violation. What could the agent be required to pay? What could the broker-dealer be required to pay? Civil liability. Recover the amount paid on the security, or advice, if it's an investment advisor, less the income, plus court costs and legal fees. Now, what if the broker-dealer finds that a violation of the USA has occurred? The client doesn't know about it. The client doesn't know about it. The broker-dealer finds a violation of the USA is concerned, or an investment advisor does. What could they do in order to settle the matter with a client? Well, they would notify the client that a violation has occurred. They would then offer to settle this matter with the client. Client has 30 days to accept that offer. What would the broker-dealer or the investment advisor pay? They would pay the amount that the client paid for the security or advice, less any income, but in this case there's no court cost, no legal fees. Now this process is known as rescission. Now I want you to note that the client has been notified by the broker-dealer or the investment advisor that a violation of the USA has occurred. Client didn't know it. Boo-boo, our bad, we made a mistake. We'll give you your money back, less any income you received. That offer is good for 30 days. If the client does not accept that offer in 30 days, they lose their right to sue. Now, the statute of limitation for civil matters would be the sooner of 3 years from the violation or 2 years from discovery. What other court-ordered penalties could be imposed? Well, there could be criminal penalties imposed. So we violated the USA. If it was a willful violation, a court could fine up to $5,000. They could also send us to prison for up to 3 years. Now you'll see here that they can do either or both. Now, the broker-dealer, the agent, investment advisor representative may not be sent to prison if they have no knowledge of the law, rule, or order that they violated. They can still be fined, but they cannot be sent to prison. Hey, listen, I didn't know that law existed. I didn't know that rule was out there. Then would not be sent to prison, but still would be fined. Now, statute of limitation under criminal proceedings would be 5 years from the violation. Non-punitive termination. Everything we've talked about so far is where someone did something wrong. Someone did something wrong. What is non-punitive termination? Well, this is where a license is canceled or withdrawn. You haven't done anything wrong. You would just withdraw your registration. That's non-punitive termination. Now, why could a registration be canceled? Registration's canceled if the registrant no longer exists. The broker-dealer's out of business. They cease to transact business. Well, they're still in business, but they're as an entity, but they're no longer buying or selling securities. Or they have been declared mentally incompetent by a court. Cancellation. The administrator would cancel registration for these situations. Now let's talk about registration. In order to be registered, we must file a registration statement. We must pay filing fees, and our registration would include a consent to service a process. Now, what is this? A consent to service a process is simply a document that you file with the administrator that gives the administrator permission to accept legal documents on your behalf. So let's say that you're an agent and a client of yours claims that you violated the Uniform Securities Act, and they're going to issue a subpoena of some sort. They want to get books and records from you or your broker-dealer. So they've issued a subpoena. That subpoena has to be served. Consent to service a process says that subpoena can be served on the administrator in your state, and that's just as good as serving that on you. Now, this consent to service a process is a permanent document. Now, when would my registration become effective? Registration becomes effective at noon on the 30th day following your application to register. Now, could the administrator shorten this registration period? They could. Could they lengthen it? They cannot. They cannot. Now be careful. Your registration is effective at noon on the 30th day following your application. Let's say that you are registering as an agent in Nebraska. On the 30th day after your application to register, at 10 a.m., you execute a trade for a client in Nebraska. Did this violate the USA? It did, because your registration was not effective in Nebraska until noon on the 30th day after filing. Now, your registration, your license, must be renewed annually no later than December 31. Let's say that you got your Series 63 license December 1 of this year. When would it have to be renewed? No later than December 31 of this year. Now let's talk about registration of a broker-dealer, BD. In order for a broker-dealer to do business in a state, they must be registered in that state before doing business. If a broker-dealer has an office in the state, they must register. Now, let's say that a broker-dealer has no office in the state, but they have public clients in the state. They must register. Give you an example of what I'm talking about. I'm a broker-dealer, duly licensed in Georgia. I have offices in Georgia. I have no offices in Alabama, but I have clients in Alabama. My clients are public clients, individual investors. They're residents of Alabama. Would I have to register as a broker-dealer in Alabama? I would, because I have clients in that state. Now, broker-dealer need not register if they have no office in the state and public clients are not residents of the state, or if they have no offices in the state and their only clients are institutional investors in the state. Let's explore this just a bit. Let's say that I'm a broker-dealer duly licensed in the state of Wisconsin. My offices are in Wisconsin. I have clients who are residents of Wisconsin. Every year, some of my clients go to Florida and they spend the winter months. Now, my clients are temporarily in Florida. They are not residents of Florida. They're residents of Wisconsin. I have no office in Florida. Can I continue to do business with my clients while they are temporarily in Florida? Absolutely. Would I have to register in Florida? No, I wouldn't. No, I would not. Would not. Now, let's change that scenario. Let's say that I'm a broker-dealer, duly licensed in the state of Wisconsin, have offices in Wisconsin, have clients who are residents of Wisconsin. My clients spend part of the year in Florida. They're temporary residents of Florida. They go down to Florida in the wintertime. I open an office in Florida to service my clients while they're there. place for them to pick up checks, drop off checks, pick up certificates, drop off certificates, place for them to come, sit around, and watch the market. Would I have to register in Florida as a broker-dealer? I would. I would, because I have an office. So my clients are not residents, but have an office, I must register. Now, I'm a broker-dealer, duly licensed in the state of California, have offices in California. I have clients in Nevada. My clients are institutional clients, banks, investment advisors, other broker-dealers. Do I have to register as a broker-dealer in Nevada? No. I have no office. My clients are institutional clients. They're not the public. Therefore, I don't have to register in that state. Remember, the Uniform Securities Act is designed to protect the public, not institutions. Public, not institutions. Now, different scenario. I am a broker-dealer, duly licensed in the state of California, have offices in California. I also have an office in Nevada. I have clients in Nevada. These clients are institutional clients, banks, broker-dealers, investment advisors. Do I have to register as a broker-dealer in Nevada? Absolutely. If I have an office, I must register. Now let's talk about registration of an agent. Now, mentioned this earlier. Who does the agent represent? They represent the BD, the broker-dealer. Now, an agent would register as an individual. You'd never have an entity, a corporation, a partnership registering as an agent. It would be an individual. Must register in every state you're doing business. If you have clients in the state, you must register. Cannot register in a state if the BD is not registered in the state. I think this just makes sense. You work for a broker-dealer. Your broker-dealer is not registered in Virginia. Well, if your broker-dealer is not in Virginia, you can't be in Virginia. What about registration of an IA? An IA that has AUM, assets under management, of less than $100 million must register with the state. If they have an office in the state, they must register. Now, need not register in a state, have no office in the state, and institutional clients only in the state. Have no office in the state, no more than 5 public clients that are residents of the state in 12 consecutive months. This is the de minimis rule. Now, this is different than the broker-dealer. Let's kind of explore this just a little bit. Let's say that I am an investment advisor registered in the state of Georgia. I have offices in the state of Georgia. I have clients who are residents of South Carolina. I have no office in South Carolina. Do I have to register as an IA in South Carolina? No, I don't. As long as I have no more than 5 public clients who are residents of the state in 12 consecutive months. So I have 5 clients in the state. I don't have to register. Now, what about this? I'm an investment advisor, duly licensed in the state of Georgia. I have offices in the state of Georgia. I have no office in South Carolina. I have clients in South Carolina, public customers. In fact, I have 6 clients who are residents of South Carolina in 12 consecutive months. Would I have to register as an investment advisor in South Carolina? I would. I would, because the number of clients that I have exceeds the de minimis rule. What's the de minimis rule? No more than 5 public clients in a state. Now, different scenario. I am an investment advisor, duly licensed in Georgia, have offices in Georgia. I also have an office in South Carolina. I have institutional clients in South Carolina. Would I have to register in the state? I have an office. I must register. What if I have an office in South Carolina and I have 4 public clients who are residents of South Carolina in 12 consecutive months. 4. What was the de minimis number? No more than 5, so that actually falls under the de minimis number. Do I have to register? I have an office, I must register. I have an office, I must register. So the de minimis rule only applies if the investment advisor has no office in the state. Now let's talk about the investment advisor representative. You'll see this on the test as the IAR. Now, the IAR represents the IA. That includes associated persons, partners, officers, or directors of an IA. Now, the IAR, just like the agent, must register as an individual, not any type of entity. Now, let's be real careful here, folks. The IAR must register with the state only. Must register with the state only. An IAR would never register with the SEC. Now, we're going to see a bit later that a IA may have to register with the SEC, but the IAR would register with the state only. Withdrawal of registration. You decided that you no longer want to be registered in a state. You are going to withdraw your registration. That withdrawal would be effective 30 days after application to withdraw. But now let's be careful. Let's say that someone has claimed you have violated the USA in the state, and the administrator is conducting an investigation, or there's some type of proceeding underway. In this case, you cannot withdraw your registration in that state until that matter has been resolved. Now, who must notify the administrator of withdrawal of registration? Well, if it's the broker-dealer withdrawing registration, it would be the broker-dealer. What if it's the agent withdrawing registration? Then it would be the broker-dealer and the agent. What if it's an IA withdrawing registration? Well, it would be the IA if they are a state IA. Remember earlier we said that some IAs register with the state, some register with the SEC. So if we have an IA registered with the state and they terminate, they withdraw registration, they notify the administrator. Would the IA who's registered with the SEC notify the state? No, they're not registered with the state. So they would notify the SEC. What about the IAR? Remember, the IAR is the person who represents the IA. So we have an IAR terminating, withdrawing their registration. Who notifies the administrator? Well, the IA would if the IAR works for a state IA. The IAR would if the IAR works for a federal IA. Now, I'm going to repeat that. Who notifies the administrator? I'm an IAR. I work for investment advisor ABC. My investment advisor is registered with the state. I leave. Who notifies the administrator of my withdrawal? My IA does. What if I'm an IA and I work for an IAR and I work for an IA, say the XYZ IA, who's registered with the SEC, and I withdraw registration? Who notifies the administrator? Well, my IA, XYZ, is a federally covered advisor. They're not registered with the state, so they would not be involved in this. I would notify the administrator of my termination. Now let's be careful, folks. If an agent terminates, who notifies the administrator? Both the broker-dealer and the agent. If an IAR terminates, who notifies the administrator? Well, it depends. If the IAR worked for a state IA, the IA would. If the IAR works for a federal IA, the IAR would. Now, we're going to get in detail a bit later as to who must register with the state, who must register with the SEC, and we'll kind of explore this again when we get to that. But right now, make sure you understand the broker-dealer, the agent terminates, both the agent and broker-dealer notify. IAR terminates, it's either the IA or the IAR. Now, what are the financial measurements for a broker-dealer or an investment advisor? That's known as minimum net capital, also known as minimum net worth. Shouldn't say also known as. They're two different financial measurements here. So we have minimum net capital and minimum net worth. Who has to meet minimum net capital requirements? That would be a broker-dealer. Now, the administrator will set the minimum net capital requirements that the broker-dealer must meet. Now, whatever the administrator sets, the minimum net capital cannot exceed that established by the Securities Exchange Act of 1934. Now, folks, don't get all hung up here on, am I going to have to calculate net capital? No, you're not. You simply need to know what financial measurement applies to who. And the financial measurement that applies to a broker-dealer is net capital. Now, an IA must meet minimum net worth requirements. Now, they only meet this minimum net worth requirements if the IA maintains custody or has discretion. Now, what's custody? The customer has their stocks, bonds, and cash on deposit with the IA. What's discretion? This is where the IA makes trading decisions regarding the customer's account. In order for an IA to have custody, minimum net worth is $35,000. What if instead they have discretion? Minimum net worth is $10,000. What if the advisor doesn't have the minimum net worth for custody or discretion? Might they still have custody or discretion? They might. They would have to purchase a surety bond, also known as a fidelity bond, in lieu of that net worth, and that is $35,000. Now, please take a look at the note here. It's been reported that the North American Securities Administrators Association, NASA, is using the term net capital for net worth on the exam, so don't let them trip you up there. By the way, North American Securities Administrators Association, NASA, that's the body that is administering the Series 63 exam. Not a broker-dealer. Now, on the test, folks, you're going to see a lot of questions about what things are, but you're going to see a lot of questions about what things are not. The following would not be a broker-dealer. All the following would be a broker-dealer except. So you need to understand what things are not. A broker-dealer is not an agent. An agent's an agent. A broker-dealer is not an issuer. An issuer is an issuer. A broker-dealer is not a bank. A bank is a bank. So what is a broker-dealer? You need to know the definition. Also need to know what is not a broker-dealer. Agents, issuers, and banks are not broker-dealers. Well, Dave, that's pretty simple. It is. It gets a little more complicated as we move along. Not an agent. A person who represents an issuer in selling securities in an exempt transaction or exempt security if no commission is paid. Now, we'll get into what an exempt transaction is. We'll get into exempt securities, what they are a bit later. The key that I want to point out to you here is no commission is paid. Also, not an agent. An officer, director, or employee of an issuer selling the issuer's stock to employees of the issuer if no commission is paid. Let's say I work for Corporation XYZ. I work for Corporation XYZ. I could be an officer, director, or an employee. I work for Corporation XYZ, and I'm going to be selling XYZ stock to XYZ employees. You know, part of a stock purchase plan. XYZ pays me my normal salary, but they don't pay a commission to sell these securities. Then I would not be an agent. But if they did pay a commission to sell those securities, I would, under the USA, be defined as an agent. Once again, no compensation. A clerical employee or administrative employee that does not solicit or accept orders would not be an agent. Officer of a broker-dealer with no sales responsibilities would not be an agent. person with no place of business selling to existing clients, not residents of the state. That's that temporary resident issue. So let's say that I am an agent. I work for a broker-dealer. Broker-dealer's licensed in Wisconsin. I'm licensed in Wisconsin. Broker-dealer has offices in Wisconsin. We have clients who are residents of Wisconsin. Some of the year, our clients spend time in Florida. They're temporary residents of Florida. My broker-dealer has no office in the state. Can I do business with my clients while they're in Florida? Yes. Would I have to register as an agent in Florida? No. No. My broker-dealer doesn't have to register, neither do I. Now, if my broker-dealer opened an office, they would have to register, and so would I. So this only works if there's no place of business in the state. Not a person. Now, see, let's define who a person is. Now, let's define who a person is not. The following would not be a person according to the USA. A minor, someone deceased, someone been declared mentally incompetent by a court. Now, I believe I said this earlier. For the test, make a person really easy under the USA. If it can open an account, it's a person. Can a minor open an account? No. Can someone who's dead open an account? No. Can someone who has been declared mentally incompetent by a court open an account? No. So these three cannot open an account, therefore they are not a person as defined by the Uniform Securities Act, as defined by the USA. Now, who would be excluded from the definition of an IA? Well, an IAR is not an IA because the IAR is an IAR. Who else is not an IA? A BD, a broker-dealer, is not an IA unless they charge a wrap fee. Unless they charge a wrap fee. Now, a wrap fee is an asset-based fee that a broker-dealer charges a customer. It's an annual fee based on the value of the assets in the account. If a broker-dealer has this type of account and charges that asset-based fee based on the value of the assets in the account, then that broker-dealer would be an IA. Who else is not an IA? Banks or anything that sounds like a bank? Who else? Not an IA. Lawyer, accountant, teacher, and engineer. The acronym LATE is a great way to remember this. Now, this is true as long as any advice they give is incidental, as long as any investment advice they give is incidental to the services they're being paid for. What does that mean? Let's say that I go to an accountant and I ask them to prepare my tax return. They do. They do. I go to their office to pick up my tax return. I write them a check for their services rendered. I write them a check. I pay them for preparing my tax return. They give me a report. They recommend that I buy municipal bonds for tax-free income. Now, did they give me investment advice? They did. They recommend I buy municipal bonds. Did I pay for that advice? I did not. I paid for them to prepare my taxes. Therefore, the advice they gave was incidental to the services I paid for. They would not be defined as an IA. Different scenario. Let's say that I go to an accountant and I ask them to help me put together an investment plan. What should I buy? What should I sell? When should I buy? When should I sell? Now, they're going to give me investment advice, and I'm going to pay for that advice. In this case, the accountant would be defined as an IA and would have to register. Also excluded from the definition of an IA and would not register would be the publisher of a periodical in general and regular circulation. If you can go into a newsstand and buy a periodical, then the publisher of that periodical is not an investment advisor. So the publisher of the Wall Street Journal, not an investment advisor. A publisher of Money Magazine, not an investment advisor. publisher of Investors Business Daily, not an investment advisor. Now, do those periodicals give investment advice? Yeah, they do. They do. But they're very general in nature. Very general in nature. And the advice has to be general to satisfy the broad, regular circulation that the periodical has. Can't be specific to a client's investment needs. Now, let's say that I like option trading. I subscribe to a newsletter that gives me information specific to option trading. The information I get from this periodical is not general in nature. It's very specific to my investment needs. In this case, the publisher would be defined as an IA and would have to register. Now let's explore a federally covered advisor. The NASMIA, National Security Markets Improvement Act of 1996, created a group of advisors exempt from state registration. This group of advisors is known as federally covered advisors. These advisors would have to register with the SEC. They would not register with the state. Now, who would register with the SEC? Federally covered advisor. If an advisor has assets under management of $100 million or more, they may be required to register with the SEC, or they may elect to register with the SEC. Let's say we have an investment advisor who has assets under management of more than $110 million. They register with the SEC. What if they have assets under management of between 100 and 110 million? They register with the SEC, or they may register with the state. So over 110 million must register with the SEC. Between 100 and 110 million may register with the SEC or the state. Now, Dave, what would be the advantage of registering with the SEC versus the state, or the state versus the SEC? I don't know. I don't care. That's not on the test. What's on the test are these thresholds here. Now, what advisor has to register with the state must register with the state? If they have less than $100 million under management, they register with the state. They register with the state. Now, federally covered advisors are regulated by the Investment Advisors Act of 1940. Now, while a federally covered advisor does not have to register with the state, they have to provide to the state something known as notice filing. Now, they file their registration forms with the SEC. They file a consent to service a process with the state. They also file those registration forms they sent to the SEC with the state, and they pay filing fees. So while they're not registering in the state, there's still things the state wants. They want a copy of the registration forms that were sent to the SEC, sent to the state. They want a consent to service process sent to the state. And of course, the state wants to collect their filing fees. Now, let's kind of explore this just a little bit. Let's say that you're an investment advisor. You have $115 million under management. Who do you register with? SEC. What if you have $95 million under management? Who do you register with? Well, I would register with the state. I would register with the state. Under $100 million, I register with the state. What if I have $105 million under management? My choice. I could register with the state or the SEC, but not both. But not both. Let's go back and explore who has to notify the administrator if a registration is withdrawn. Let's say that you're an IA, you manage $115 million. You withdraw your registration. Would you notify the state? No, because you're registered with the SEC. What if you have $95 million under management? Who would you notify of the withdrawal? Well, less than $100 million, you notify the state because you're registered with the state. Let's look at a different scenario. Let's say that you're an investment advisor, you're an IA, and I'm an IAR who works for you. I represent you. You have $115 million under management. I decide to withdraw my registration. Who notifies the administrator? I would, the IAR. You would not because you're registered with the SEC. You're not registered with the state. I'm registered with the state. I would notify the state. Now, let's say that you're an IA. You have $95 million under management. You're registered with the state. I'm an IAR. I represent you. I'm registered with the state as well. I decide to withdraw my registration. Who notifies the administrator? The IA does. You, the IA, would notify the administrator. If it's a state-registered investment advisor, they notify the administrator of the IAR's termination. If it's a federally covered advisor, the IAR notifies the administrator of the termination. Now, folks, is that kind of confusing? Well, a little bit. But, you know, it's like everything else. You've got to study in order to pass this test. You know, this test is a bit of a challenge because the information is pretty detailed. Now let's change paths here, and let's start talking about securities. Classification of securities. Well, there are three classifications of securities as it relates to the USA. The first would be exempt securities, next would be federally covered securities, and last would be non-exempt securities. Now, non-exempt securities must be registered with the state. Exempt securities and federally covered securities don't have to register with the state, but non-exempt securities must register with the state. Now, let's explore what an exempt security is. An exempt security would be a security exempt from state registration and advertising filing provisions of the USA, but not the anti-fraud provision. So if you're selling an exempt security and you engage in fraudulent activity, then the administrator could come after you. Now, with exempt securities, the exemption is based on who the issuer is. Now, here's a list of exempt securities. Now, folks, I want you to memorize the list. People struggle with exempt securities. They really struggle with exempt securities. Exempt securities are really fairly easy. It's simply a list of securities that are exempt, and you need to memorize the list. Now, top of the list, exempt securities would include U.S. and Canadian government new issues. Exempt securities would include U.S. and Canadian municipal new issues. Exempt would include recognized foreign governments, but not foreign municipals. Financial institutions like banks or savings and loans. Insurance companies. Public utilities. Common carriers, like a trucking company. Religious and charitable organizations. Commercial paper and banker's acceptance, as long as the maximum maturity is 270 days, which is 9 months, and the minimum amount that's being issued is $50,000. What if we don't satisfy that? What if the maximum maturity is more than 270 or the minimum is less than 50? Then they would no longer be exempt securities. Employee pension and profit sharing or savings plans and federally covered securities, these are all exempt securities. Now, folks, it's a list and you need to memorize it. I do want to talk a little bit about the second item there on the slide and the third item on the slide. U.S. and Canadian municipals. Let's go ahead and talk about the first, second, and third. U.S. and Canadian government, U.S. and Canadian municipals, and recognized foreign governments, but not foreign municipals. What exactly does that mean? Well, let's say that the U.S. government wants to sell some T-notes in the state of Georgia. Well, they're exempt. They're U.S. government securities. What if the Canadian federal government wanted to sell some Canadian bonds in Georgia? They're exempt, would not have to register in Georgia. What if the city of Denver, Colorado wanted to sell some new issues in Georgia? Will they be exempt? That's a U.S. municipal, exempt. What if the city of Toronto, Canada wanted to sell some new bonds in Georgia? They would be exempt, would be exempt from registration. Now, what if the country of Great Britain wanted to sell some bonds of the national government in Georgia? They're exempt. We have diplomatic relations. We recognize that foreign government. We have diplomatic relations. Their new issues would be exempt. Now, those are new issues of the federal government, the national government of a foreign country. What if the city of London, England, wanted to sell some new bonds in Georgia? Those would not be exempt. They would have to be registered. So the point that I want to make sure you're clear on, are municipals exempt from registration? Yes, if they are issued, if their security is issued by a municipality in the U.S. or in Canada. No other municipalities would have their new issues exempt. What if the country of Mexico wanted to sell some new bonds in Texas? Would they be exempt? Yes, they would be, because that is a foreign government with which we have diplomatic relations, and that's the national government selling the bonds. What if the city of Mexico City wanted to sell some new bonds in Texas? Would they be exempt? No, they would not. Those bonds would have to be registered in Texas. Now, federally covered securities. The National Securities Markets Improvement Act of 1996, NSMIA, created a group of securities exempt from state registration, but not the anti-fraud provision of the USA. This group of securities is known as federally covered securities. And this group would include securities issued by the U.S. government, securities issued by municipalities, except if issuer in state of offer or sale, securities listed on an exchange and those on the NASDAQ stock market, including senior securities, investment company securities, and securities issued under Regulation D, private placements. Now let's explore a couple of these. Let's say that we have the city of Atlanta, Georgia, who wants to sell some new municipal bonds in Alabama. Are they considered federally covered? They are. They are. What if the city of Atlanta wanted to sell some new municipal bonds in the state of Georgia? Would they be federally covered? No, they're not. No, they're not. Look at what it says there under municipalities, except if issuer in state of sale or offer. So municipal securities are considered to be federally covered securities in all states except for the state of issuance. Now, would those City of Atlanta bonds issued in Georgia be federally covered? No. Are they exempt? Yes. Now on the test, folks, they are going to ask you questions, so you've got to know what is an exempt security versus federally covered. Give you an example. All the following would be considered federally covered securities except, or all the following would be considered exempt securities except. One of the answers they're going to give you would be federally covered. All the others would be exempt, and you've just got to figure out what's what. Okay? So that one's tricky. I'm going to go back one slide, two slides. What's tricky here has to do with the municipalities issuing new securities. What municipals are exempt? That would be U.S. and Canadian. Now, are U.S. municipals also federally covered? Yes, in every state except for the state of issuance. In the state of issuance, are they federally covered? No. Are they exempt? Yes. Yes. Also on this slide here, be careful of that foreign government. While the national government's new issues are considered exempt securities, not the municipals within that foreign country. Only foreign municipals that would be considered exempt securities would be Canadian municipals. Now, back to this slide, federally covered securities. Investment company securities, that's the face amount certificate company, unit investment trust, the management companies, and then the private placements. Those last two you saw as part of the Series 6 preparation. Now, registration of securities. Registration of securities. Non-exempt securities must be registered unless those securities are sold as part of an exempt transaction. Oh my goodness. Now, with non-exempt securities, prospectus must be delivered at or before solicitation. There are three types of securities registrations. There's notice filing, there's coordination, there's qualification. Those are the three. Let's look at these three in some detail. Notice filing. This is the easiest and fastest form of state registration, if you will. Actually, I hate to call it registration because technically it's not. Notice filing is used with federally covered securities, most often used with investment companies registered under the Investment Company Act of 1940. And what this says is that an investment company registered under the Investment Company Act of 1940 must file copies of their registration statement with the state that they filed with the SEC, and they pay filing fees. So while investment company new issues are exempt from registration, the investment company must file notice filing, which is simply a copy of the registration statement filed with the SEC, and pay the state filing fees. Now let's talk about registration of securities by coordination. Most IPOs use this. Registration documents filed with the SEC and the state. Got to pay filing fees to the state. When would the new issue become effective in the state? Same time it would become effective under federal registration. Now, coordination is real simple. If we have a company that's got to register their new issue with the SEC and register their new issue with the state, then they can register using coordination with the state. So they coordinate registration with the SEC and the state. So in order to use coordination, there must be an SEC registration component. Next, we have qualification. This is the most difficult and complex form of registration. We really don't want to do it if we can avoid it. This is most often used with intrastate offerings. Now, what's an intrastate offering? This is a new issue that is going to be sold in one state only. Going to be sold in one state only. Since the new issue is sold in one state only, there would be no SEC registration component. So we could not use coordination. There would be no SEC registration component. So we could not use coordination. We're only registering with the state, we use qualification. Now, what would the issuer do? They would file complete registration documents with the administrator. They would pay filing fees. When would the new issue become effective in the state? Whenever the administrator says it's effective. So the administrator could have the issuer jump through a lot of hoops and just drag out the registration process here. Now let's talk about exempt transactions. Transactions exempt from state registration and advertised filing provisions of the USA, but not the anti-fraud provision. Exemption is based on who is involved in the transaction. Who's involved in the transaction. Now, exempt transactions, simply a list here. Isolated non-issuer transactions, unsolicited transactions, issuer transactions where the issuer is selling to an underwriter, fiduciary transactions, such as a sheriff who is selling securities that have been seized, or a trust selling securities. Now, there is one fiduciary transaction that is not considered to be exempt, and that would be custodial account transactions, minor accounts. Also exempt transactions would be transactions with financial institutions, including banks, broker-dealers, investment companies, insurance companies, pension and profit-sharing trusts. Exempt transactions include collateral transactions. A bank has taken securities on as collateral for a loan. The borrower defaults. The bank is going to sell the securities. That's an exempt transaction. Pre-organization certificates, as long as no commission is paid by the subscriber, person who is basically pledging money. Subscribers may not exceed 10, and there would be no payment by the subscriber. So the subscriber is basically pledging money as part of this pre-organization certificate. Also exempt would be a private placement. Now please, 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 don't get the private placement under the USA confused with the private placement under the SEC, under federal law. They're different. What's a private placement as defined by the USA? A private placement can be offered to no more than 10 individual investors in 12 months. Now I want you to notice here, not sold, offered to no more than 10 individual investors in 12 months. Can be offered to an unlimited number of institutional investors. No commission would be paid by the non-institutional investor. If a commission is paid, then this would no longer be an exempt transaction. Please take a look at the note here. Transactions with individual accredited investors are not exempt transactions. Now, kind of going back to Series 6, what's an accredited investor? This would be an investor who has net worth of $1 million or more, excluding their primary home. This would be an individual investor filing a tax return as an individual whose income was $200,000 or more each of the past 2 years. They expect the same today. If it's a married couple filing a joint tax return, that income jumps to $300,000. So those are accredited investors under federal law, but when we sell securities to those investors under state law, that's not an exempt transaction. Not an exempt transaction. All right, let's kind of pause here. Let's pause here. And let's go back. I'm going to go back a couple of slides, back several slides, in fact. We're going to go back and we're going to talk about exempt securities. Now, these securities are exempt because of who the issuer is. A financial institution, an insurance company, a public utility, the U.S. government. These are exempt because of who the issuer is. Federally covered securities are exempt because the federal government says they're exempt. If it weren't for the federal government, the states would make these issuers register their new issue. So federally covered securities are exempt because of because the federal government says they're exempt. Exempt transactions are exempt because of who the transaction is with. Because of who the transaction is with. Now folks, all three of these are simply a list. I want you to memorize the list. Let's explore these exempt transactions in a little bit more detail. What is that isolated non-issuer transaction? Isolated non-issuer transaction would be a transaction between individual investors. Doesn't involve a broker-dealer, just a couple individual investors buy and sell stocks amongst themselves. That's an isolated non-issuer transaction. That's an exempt transaction. Now, when we get done today, I'm going to go to dinner tonight with my wife and some friends. We're going to go to a Mexican restaurant. We're going to eat burritos and drink adult beverages, margaritas. During the course of the evening, my friend mentions that he wants to sell some XYZ stock. I said, well, Dagum, I want to buy some XYZ stock. So right there over cheese dip and salsa, we trade that XYZ stock. That's an isolated non-issuer transaction. That's an exempt transaction. Now, what is this unsolicited transaction? A customer comes to you and they say, I want to buy this security. That's an unsolicited trade. You sell it to them. That's an exempt transaction. That's an exempt transaction. Okay? Now, let's say that you have a client who comes to you and they want to buy a non-exempt security that is unregistered in the state. Client comes to you, they want to buy a non-exempt security that has not been registered in the state. Now remember, securities that are non-exempt must be registered in the state. These are non-exempt securities and they have not been registered in the state. You sell those securities to your client. Have you violated the USA? Have you violated the Uniform Securities Act? No, you haven't, because this was an exempt transaction. These transactions do not have to comply with USA provisions, do not have to comply with state law. Now, you can't commit fraud in selling those securities, can't commit fraud, then the USA would slap you, but you could sell them, no problem, because that is an exempt transaction. Now let's slide down to transactions with financial institutions. And let's look at the insurance company. Now, I'm going to go back a few slides. Exempt securities includes new issues of insurance companies. That is the fifth item down. Exempt securities include new issues of an insurance company. So you're going to sell insurance company stock to a client. That's an exempt security because who the issuer is. What if you're going to instead sell a new issue to an insurance company? Second from the bottom. Now, this is an exempt transaction. The first was an exempt security because of who the issuer was. The second was an exempt transaction because of who the transaction was with. This is the kind of stuff that gets people confused. And you have to really memorize the list and work through test questions. Let's talk about what a security is. A security would be defined as oil and gas drilling and mineral lease programs, condominiums used as investment, farmlands and animals, whiskey warehouse receipts, option on commodity contracts. Now folks, there's a lot of securities and we're not going to go over the list of everything that's considered a security, stocks, bonds. We're not going to do that. What I want to do here is I want to point out to you things that are a little unusual to watch out for on the test as it relates to what a security is. Again, oil and gas drilling operations and mineral lease programs. Anything involving those would be a security. Condominiums used as an investment is a security under the USA, and you would have to have a securities license to sell those. Farmlands and animals are a security under the USA. Whiskey warehouse receipts are securities under the USA. Now, I don't even know what a whiskey warehouse receipt is. It has something to do with Prohibition days, but it's on the test and it is a security. Options on commodity futures contracts. What's a commodity? Lumber, oil, wheat. So option contracts, puts and calls on a commodity futures contract is a security. Now, I want you to make sure you know what a security is not. Fixed life insurance contracts are not securities. Variable would be. Life insurance endowment contracts are not securities. Fixed annuities are not securities. Variable annuities would be. Retirement plans are not securities. Now, the plan itself, the IRA, the KEO, the plan itself is not a security. But what we buy and put into the plan would be securities. Currencies would not be securities. Commodities, lumber, oil, wheat are not securities. Futures contracts on commodities are not securities. Are not securities. Be careful. Be careful. The option contracts, puts and calls on those commodity futures contracts are securities, but the futures contracts themselves are not. Condominiums bought as a personal resident is not a security, but if you buy a condominium and you intend to rent it out, that would be a security under the USA. Let's say that I buy a condominium in Breckenridge, Colorado. I'm going to use it part of the year. Otherwise, I'm going to rent it out. According to the USA, when I buy that condominium, I just bought a security. I bought a security. But if I buy that for my personal residence, it's not a security. Discretionary authority. Broker, dealer, and agent must have written discretionary authority signed by the client before the first discretionary order can be entered. Now, what is discretion? If the agent's going to decide the action, buy or sell, or if they're going to decide the amount to buy or sell, or if they're going to decide the asset to buy or sell, that's discretion. Time and price are not discretion. In order for a broker-dealer and agent to exercise discretionary authority, they must first receive written discretionary authority signed by the client, and this must be received before the first discretionary order. What about an investment advisor? That's different. With an investment advisor, the client can give oral discretionary authority. They must follow that oral discretionary authority up with written discretionary authority within 10 business days of the first order. Now that's different. Be careful. That'll get you tripped up. Can we ever receive oral discretionary authority from a client? Broker, dealer, and agent cannot, but an IA can. Would that oral discretionary authority have to be followed up with written discretionary authority? Yes, within 10 business days of that first discretionary order. Offer or offer to sell, sale or sell. That's a mouthful. What's included in an offer or offer to sell or sell or sell? Well, that would include securities. That would include interest in securities, such as a bonus. Now, remembering back to Series 6, a bonus would be a warrant, so bonuses, rights, warrants, gifts of assessable stock. Now folks, assessable stock has not existed for many years, but it's on this test. And if you give away assessable stock, that was a sale. If you attempt to give it away, that was an offer. Now, for the exam, you don't need to understand what assessable stock is, but I'm going to explain it to you just so you know what we're talking about here. Assessable stock is stock that is issued in an amount less than its par value. A stock whose offering price is less than par value. Let's say that a company sells stock for $25. That's the offering price. And the par value is $50. This is assessable stock. This is assessable stock. If the company goes out of business, The creditors of that company can assess against the shareholders of the company the difference between the price they paid, 25, and the par value of 50. That's assessable stock. If you attempt to give that away, that was an offer. If you do give that away, that is a sale. Now, excluded from the definition, if you will, of an offer or sale, stock dividends. If you receive a stock dividend, that's not an offer, that's not a sale. Securities pledged as collateral. You go to a bank to borrow money. They say, we need collateral. That's why I've got stock in the XYZ Corporation, I'll pledge. That's not an offer or sale. Securities exchanged due to a merger or reorganization, not an offer or sale. I work for the XYZ Corporation. We merge with the ABC Corporation. New securities are issued. That would not be an offer or sale. If you give away non-assessable stock, that would not be a sale. If you attempt to give it away, that would not be an offer. Now, what is non-assessable stock? This is stock that is issued with an offering price greater than par value. And as I said a few moments ago, assessable stock has not existed for years, but you'll see it on this test. Now, an IA, investment advisor's contract. So here we're talking about a contract that the investment advisor has with their client. The contract must be written, must detail services and fees. Investment advisor details in the contract what they will do, what services they provide, and what fees they charge. Now, this contract cannot be assigned without client consent. A majority change in a partnership is the same as assignment. A minority change in partnership requires client notification. That's not assignment. Advisory brochure. The investment advisor has a brochure. Basically, it's a marketing brochure. They must provide that at least 48 hours before client signs a contract. If they do not provide that brochure within that time period, at least 48 hours before signing the contract, then they must give the client a 5-day free look period. If the client wants to cancel that contract within that 5-day period, they would receive back any money that they had paid to the IA. And the contract must terminate. It cannot be a contract paid in perpetuity. It cannot be a contract that exists in perpetuity, that exists forever. It must terminate and can be renewed. Now let's go back and explore some of the information here. Let's talk about the third item down. Cannot be assigned without client consent. Let's say that you are a client of mine. I'm the investment advisor, you're my client. You have spent months researching investment advisors. You've interviewed several investment advisors. You decide that you are going to do business with me, and we sign a contract. I've got a friend who's an investment advisor just starting their business. I've decided I would like to assign your contract to my friend to help them get started. I cannot assign this contract without your consent. I cannot assign this contract without your consent. Now, what is that majority change in partnership? Let's say that I'm the IA, you're my client. The IA is organized as a partnership. I own a majority interest in the partnership. Let's say that I own 55% of the partnership. I've decided I want to sell my interest in the partnership. I want to leave the partnership. This would be a majority change of partnership. I cannot do that without client consent. That is basically a form of assignment. Now, what if the amount of the partnership I own is a minority interest? Let's say that I own 48% of the partnership. I want to sell out to another partner. This is a minority change of ownership. This simply requires client notification. Hey client, this partner is leaving, and here's the new partner coming in. Advisory fees. Any fee that an advisor charges must be reasonable. Now their fee is going to be based on a formula, and this formula would be found in the contract. However, the fee cannot be based on account performance or capital gains. Agency cross transactions. This is where the IA acts as an agent for the client and other party in a trade. So we have a buyer and seller. The AA may not recommend to both sides, must receive client consent before the transaction, must disclose the following: that the consent can be withdrawn at any time, agency cross transactions on customer's account statement, nature of the transaction, date of the transaction, and commissions earned. What is this talking about? Here's what it's talking about. I'm an investment advisor. You're my client. You come to the office one morning for a meeting. I recommend that you buy XYZ stock. Later that day, I'm playing golf with a friend of mine. On about the 5th hole, my friend says to me, you know, I've got some XYZ stock I'm looking to sell. I tell my friend, well, yeah, I've got a client who's looking to buy that stock. How about I act as an agent for the two of you and put that trade together? This is an agency cross transaction. You notice that I recommended the trade to my client, but I did not recommend the trade to my friend. So I cannot recommend to both sides. Now, before I act as an agent and complete this transaction, I must give my client notification of what I'm doing and must get their consent. And then I would have to disclose to them. Now look, you can withdraw this consent at any time before this trade is executed. I would have to display the fact that this was an agency cross transaction in the customer's statement. I would tell the client, look, I'm acting as an agent for you and the other party. I would have to disclose the date the transaction occurred, and I would have to disclose commissions earned. That's an agency cross transaction. Soft dollar compensation. Wow! Soft dollars is a term generally used in the asset management and securities industry to describe the research or other benefits provided to an asset manager by a broker-dealer as a result of commissions generated from financial transactions executed by the broker-dealer for client accounts or fund managed by the asset manager. A soft dollar arrangement is one in which the investment manager directs the commissions generated by the transaction towards a third party or in-house party in exchange for services that are the benefit of the client but are not client directed. Oh my goodness gracious. There you know what soft dollar compensation is. But you don't really need to worry about that for the test. What you need to worry about for the test is what's considered to be acceptable soft dollar compensation and what's not acceptable soft dollar compensation. Now, what is acceptable soft dollar compensation would be defined under Section 28E. That's the safe harbor rule. That's part of SEC regulations. And you see there what acceptable soft dollar compensation would be under safe harbor. Research reports, securities analytical software, financial periodicals, seminars, conferences, affecting and clearing trades, not acceptable phone lines, internet service, rent, office, furniture, computer equipment, software not relating to securities analysis, and travel expenses. Now folks, on the test, just make sure you're clear. Soft dollar compensation, what's acceptable? What would be acceptable would be things that an investment advisor could use with their clients. Not with one client, but with many or all of their clients. Might an investment advisor use research reports with their clients? Sure. Securities analytical software with their clients? Sure. Financial periodicals? Absolutely. Seminars and conferences? You want to learn more information? Yeah. Affecting and clearing trades through a broker-dealer? Yeah. These are all acceptable soft dollar compensations because all of these would benefit the clients of the investment advisor. Now, not acceptable soft dollar compensation under safe harbor, phone lines. That doesn't benefit clients, that benefits the investment advisor. Internet services, same thing. Rent, same thing. Office furniture, same thing. Computer equipment, same thing. Doesn't benefit clients of the IA, benefit the IA. Well, that's not allowed. Soft dollar compensation that would be allowed would benefit the clients of the IA, not the IA. Now, on the test, where they typically will ask questions as it relates to soft dollar compensation, has to do with what's not acceptable soft dollar compensation, and the two big ones they ask about would be rent and office furniture. Not acceptable soft dollar compensation under the safe harbor rules. Unethical business practices. Now, folks, much of this here just makes common sense. Delaying deliveries of securities and payments would be a no-no. Delaying deliveries of securities or payments would be a no-no. We have I'm a broker-dealer. I sold securities to another broker-dealer. If I delay delivering those securities to the other broker-dealer, that's unethical. That's unethical. Let's say that I bought securities from another broker-dealer. Delaying payment to that broker-dealer is unethical. Churning or switching is unethical. Now, what is churning? Churning is where we trade for the sole purpose of generating commissions. We don't care whether a transaction is suitable for the client or not. We've got a car note due next week. Somebody's buying something today. That's churning. What's switching? Well, switching is where you move a client's money from one mutual fund to another mutual fund. Rephrase that, where you move clients' money from one fund company to another fund company. That's switching. That's a form of churning. Making unsuitable recommendations would be a no-no. Transactions without authorization would be a no-no. That's unethical business practices. Let's say that you are a registered representative. You have a client who is going to travel abroad for several months, and while they're traveling, they will be unreachable. They're going to be in some remote mountain region over in the Nepal area. You can't reach them. They did not give you any type of trading authority. They did not give you discretion. They did not give you trading authority as it relates to anyone else, maybe a brother. You can't reach them. A stock in their portfolio is falling in value and falling fast. You get a call from the client's brother, sell that stock. If you accept that transaction, that's an unauthorized trade that would violate the Uniform Securities Act. Margin trading without a margin agreement violates the Uniform Securities Act. Now, what's margin trading? This is where we're buying stocks and bonds using borrowed money. In order to accept a margin trade, the client would have to sign a margin agreement. Hypothecating customer securities without consent is a no-no. What's hypothecating? Pledging a customer's securities without consent is a no-no. Commingling customer assets with a firm's assets, no-no. Soliciting without delivering a prospectus is a no-no. Charging unreasonable commissions, markups, or fees for services would not be acceptable. Now, what kind of fees for services might we be talking about here? I'm a broker-dealer. Customer has their stocks and bonds on deposit with me. I provide a place of safekeeping for that customer's securities. I could charge them a fee for that service, but that fee must be fair and reasonable. Manipulating, deceiving, defrauding, or misleading is a no-no. Guaranteeing a profit or protecting against a loss is a no-no. Can an agent ever guarantee a profit or protect against a loss? No. Can a broker-dealer? No. Can an investment advisor? No. Can an IAR? No. Fail to disclose conflicts of interest? No, no. Establish or maintain fictitious accounts is a no-no. Is a no-no. Splitting commissions unless with same or affiliated firms and properly licensed would be a no-no. Let's explore that. I'm an agent duly licensed in Georgia to sell securities. I work for broker-dealer ABC. I have a friend who's an agent in Alabama. They too work for the broker-dealer ABC. They're licensed to sell securities in Alabama. Can we split commissions between the two of us? Well, our firm is the same firm, so they're affiliated. I like that. I'm licensed in Georgia. My friend's licensed in Alabama, but we're really not properly licensed yet to share commissions. See, to share commissions, I would have to be licensed in Georgia and have a non-resident license in Alabama. My friend would be licensed in Alabama and have a non-resident license in Georgia. Now, we did all those things. Now we can split commissions. Let's say that I am an agent. I am licensed in Georgia and Alabama. I work for broker-dealer ABC. I have a friend who's an agent for a broker-dealer in Alabama. My friend's licensed in Alabama and licensed in Georgia. They work for broker-dealer MMLJ. Two different broker-dealers, no affiliation whatsoever. Could they split commissions? No, they could not unless the administrator approved it. We continue with unethical business practices. Trading before a client, known as front running. Can't do that. Can't do that. You know, I'm an investment advisor. I'm about to recommend to all my clients invested in the XYZ fund that they should sell their XYZ fund. I'm invested with XYZ as well, and I sell my shares before I recommend to my clients. That's a no-no. That's called front running. You can't do that. Spreading rumors, can't do that. Selling away. This is selling securities that a firm does not offer. This is not allowed unless the trade is approved by the firm or the broker-dealer. Failure to disclose all sales charges would be a no-no. This would include front-end sales charges, back-end sales charges, known as the CDSC, contingent deferred sales charge. Also, asset-based fees. This would be the wrap fee. This would be the 12B1 fee. That's the trails. That's the trails. And folks, that brings us to the end of Series 63. Now, before we sign off, I want to tell you, you need to be very, very careful about this test. Many people believe this exam is more difficult than Series 6. I kind of believe that myself. I fall into that camp. People underestimate Series 63 all the time. They get the Series 6 book and it looks like that. They get the Series 63 book and it looks like that. And they think, man, this is going to be a piece of cake. This is really going to be easy. The exam is very difficult. The questions are worded like a lawyer would word them. They're very long. They're very wordy. Many times the question does not fit onto the screen, the computer screen at the test center. You have to scroll to another page to see the full question. You have 75 minutes for 65 questions. That's a little over a minute per question. There are many challenges with this exam, but here's the deal. If you study, if you put in the work, you can pass this test. Now, go get busy, read the book, watch the videos, work on practice questions, pass the exam, and then you can move on with your life.